The Australian Security Academy acknowledges the traditional owners of country throughout Australia and recognises the continuing connection to lands, waters and communities. We pay our respect to Aboriginal and Torres Strait Islander cultures and to elders past and present. Aboriginal and Torres Strait Islander people should be aware that this series of live streams contains images or names of people who have passed away. Welcome along, everybody, to episode 150 of Investigations Uni. I'm very proud of that. And this is the program each week for continuous professional development for Australian Security Academy students and graduates. Here, you get an email invite each week, which has replayable on demand. You click on any one of those links in that invite and you can watch all 150 episodes at any time you want to watch them when your footy team's losing in the afternoon. Each week we get here to consistently deliver deeper investigations learning, risk learning, fraud control learning, that sort of thing in a 3/4 of an hour format each week. So we're consistent about it. It's not like a conference you attend for 1 day or 2 days, which is intensity. We're consistently delivering a new subject each week, a new way of doing things, and that can apply to all sorts of other areas where you do it. We might talk about general insurance investigation fraud. The principles we talk about that apply in workers' compensation or CTP liability fraud. These things cross over. Investigations is something where 5 + 5 does not always equal 10. It's not that straightforward. There is lots of different factors that are involved, and these include environmental factors, human factors, emotional factors, process, policy, procedure, legislation, and legal factors, and how they are interpreted and read by the people that have to make those decisions. So we are here each week to consistently deliver on improvements and continuous professional development in your investigation career. Here we go. G'day, how you going? Great to see you. Thanks, Ned. Thanks for saying hello. Thanks for checking in. Hi, Nicola. Great to see you. Thanks for saying hello. Hey, along. Great to see you. G'day, Amber. Fantastic. Happy Merry Christmas, everybody, and have a safe and happy New Year. Great to see you checking in. Thanks, Amber. Brooke, really good to see you, Brooke, in beautiful northern New South Wales. I'm sure it's a lovely day there today, Brooke. I'm sure you'll enjoy today's program. There's a lot of information into it. And Georgia, great to see you. Thanks for saying hello, everybody. It's really comforting to know that we actually have an audience watching each week. It motivates us basically to behave ourselves and deliver on that promise. So thanks for saying hello, people, and thank you for checking in. My pleasure to introduce once again Andrew Baldock, Andrew the Doc Baldock, to talk us through issues around workers' compensation investigations. And today, Andrew, what are you talking about today, mate?
Yeah, pre-injury, injury and post-injury information that we want to include in our reports. So that's what I'll be talking about today, extending on that a little bit so that first-time persons writing reports get a bit of a better understanding of the information that they need to include. May not be prevalent so much to people that are seasoned in the industry, but hopefully you can pick up 1 or 2 tips.
Well, it's really important because the logical sequence is pre-injury, injury, and post-injury. If you're writing an investigation report and you start off post-injury and then you pop around to injury and then you go backwards into pre-injury, everybody reading is going to say, that's completely out of order. I am totally confused. I don't know what I'm doing. So these are the areas that you will focus on when gathering information for your report writing processes. So always think when you get a workers' compensation investigation or any form of investigation, pre-incident, incident, and post-incident, they're the areas that you are going to be exploring. With what Andrew is talking about today, it goes into other areas too. And you've heard me say it till I'm blue in the face. In workers' compensation, what Andrew is going to cover today, you can put into these categories: training, supervision, system of work, warnings, personal protection equipment, and is the person a worker? The price of eggs in China is not relevant to what we're talking about today. What is relevant are pre-injury, injury, and post-injury within those things that you see on your screen right now. I'll get out of the way and let Andrew do his presentation.
Thanks, Mike. So you can probably extend on that a little bit too, ladies and gentlemen. You can also have treatment as well. So some, companies want you to put treatment. So that's another subheading. Well, just got to bring this up so I can actually see this a bit better. That's better. So we might just go to the next slide if we can there, Mike. Thanks, Mike. So who is the worker normally supervised by within the course of undertaking their duties? So are they supervised in their duties, or are they left to undertake their duties with minimal supervision? Is there a team leader, or is there somebody they report to regularly that's actually consistently watching over them on the floor? What level of supervision do they require? So this might be somebody that might be deemed incompetent and needs a lot more assistance than the average person. Or it could be somebody who's been there for 30 years and really knows more about the business than anybody else. So we might go to the next slide again there, Mike. Now, you'll see on the last slide, actually, how does a worker normally receive their instructions? So they might give instructions via verbal communication. It might be written communication. They might have job sheets. They might have things such as WhatsApp messages. They might have morning Facebook groups or whatever you use these days, because everything's changing all the time. So how to manually operate an excavator? Well, I would think that you would need a bit more training than that. So anyway. All right. So what qualifications does the worker require to hold relevant to their role? So they might need a white card, for example, to get on a construction site. They might have to have a degree. They might have to have other qualifications such as working with children's checks, national police checks. They might have to have a driver's license. They might have to have 12 months experience previously in a similar role. First aid certificates, those kind of things. So we list all those things, and they may not have those qualifications before they actually are employed. They may have undertaken those qualifications within their course of employment with the employer. What level of experience does a worker have within their role? Have they been doing this job for the last 2 weeks, or have they been doing this job for 30 years? Is a worker considered competent within their role? Do they know what they're doing? Has a worker undergone any induction and training? Big one. I find this very difficult at times, because the employer will say, we don't have any induction and training record, but the worker's been working for them for 30 years. How can you not have an induction and training record? Or if you don't have one, tell me, what have you provided to the worker within the course of undertaking their employment? Have you provided them with on-the-job training? Is that a recorded process or not? What did the training include? So do they go out to site and they've got to do site-specific inductions every time they go to a new site? Is there a record of that? They may not have a record necessarily for when they first started their employment. Now, a lot of the time at the moment, I'm getting employers saying we changed operating systems, so all that old information no longer exists. There's got to be some kind of record somewhere, you would think. You go to the next slide, thanks, Mike. Has the worker undergone any further training within the duration of the employment? So that's what I've just hinted on. Obtaining a copy of the induction and training record, that's just huge. I mean, you've got to be able to say what training they've provided, especially when the matter goes to common law. They're going to turn around and say, well, you've got no record or no system here to show that you've provided anything to the worker at all. So you've got to have something to protect themselves. Are you aware of the worker having any pre-existing injuries, illnesses, mental health issues, or prior claims? So sometimes what we find is the worker will state on their pre-employment medical that they don't have any pre-existing mental health issues or illnesses. And then you'll find on their workers' injury claim form, they'll say they have a prior history of anxiety and depression. So we want to find out when that was. Was it before they commenced their employment? Was it within the duration of their employment that this developed? How did it come about? So this goes back to your timeline of events, which is the chronology that we spoke about the other week. It's starting before the actual event occurred. Are you aware of the worker drinking alcohol, smoking cigarettes, or using any recreational drugs? Now, people say, well, what's smoking cigarettes got to do with it? Well, smoking cigarettes can actually affect psychiatric medication that somebody is actually taking for things like anxiety and depression. So what a lot of people don't realise is antipsychotic medication or antidepressants may take 4 to 6 weeks before it actually starts working effectively. I know that in my former role as a psychiatric nurse. Can you describe the relevant systems of work? So what do the relevant systems of work involve? Can you tell me about the job and what specifically it includes? Now that might mean that they have to don things like PPE. So, hard hats, safety boots, high-vis vests, glasses. They might have to wear a face mask or a shield. They might have to wear hearing protection, welder's apron. What manual or mechanical assistance is available to the worker within the course of undertaking their duties? Now, these things that I've said so far are all part of the pre-injury section of the report. So you could have manual handling where you're assisted by overhead hoists, cranes, pallet jacks, forklifts, and an array of other equipment. But also you could get assistance from your colleagues as required. Now, sometimes they'll turn around and say, but the employer says there's manual assistance and mechanical assistance available, but there's only one pallet jack and it's not always there. It's not always there for people to use. Sometimes they use it for other duties. So that means we have to unload everything off the pallet by hand ourselves and then carry it to another area. The rotation of duties is a big one. What rotation of duties is provided within the course of the worker undertaking their role? So in a lot of warehousing applications and manufacturing applications, you might find that persons generally move every 2 hours from one workstation to another. So we want to know the role of what they do at each of those specific areas. We also want to potentially get photographs and video footage depicting the relevant systems. Lady here who's pushing the pallet, so we would probably get video footage showing her moving that pallet from one place to another, and then if she's got to unload that pallet by hand or anything like that, breaking it down like this young lady, we want to see that she's maintaining that box close to her body and picking that up in a manner that's going to promote the safety for her back, things like that. Now, this one here that might showing where you're standing on top of a pallet on top of a forklift, obviously a big no-no. If she falls and slips from that height, she's going to be in big trouble. Okay. Do the workers' duties require them to perform any awkward and or repetitive tasks such as pushing, pulling, or undertaking heavy lifting? So if they're pushing and pulling, how often are they undertaking those duties? Are the duties repetitive and consistent? If they're lifting any heavy object, what's the weight of the object? What's the dimensions of the object? And how often are they lifting it? Where are they lifting it from and to? Are they required to carry it over 5-10 metres? Or is it just moving 1 or 2 metres from the pallet to the shelves? What's the height of the pallet off the floor? What's the height of the shelving? How many shelves are there? There might be shelves ranging from a height of 300 mils up to approximately 1.8 metres. How high is the pallet that they're breaking down? Now, the pallet might be 1.8 metres high maximum, or it might be 1.5 metres high, depending on the workplace, depending on what the weight is of the box too. So sometimes you'll find on the outside of the box, there might be a stamped weight telling you how much it weighs. So when it comes to common law and things like that, they'll ask you questions such as, did the worker assess the weight of any box or any object before lifting it? So handle with care, 23 kilograms. So you might find that you need to go and get somebody else to assist you with that. So there's Mike's breakfast that comes to his house every week. Okay. As we said, the frequency, the duration of the work being undertaken. So is this something that they do once a week for 5-10 minutes? Or is this something that they do for 4 or 5 hours every day? Before the time of the alleged incident injury, were the systems of work area, or machinery the subject of any investigation by WorkSafe or any internal investigation? So WorkSafe might have issued a notification of assessment where they've determined that the employer has certain systems or things they need to fix in the workplace. They might say, look, you don't have any adequate risk assessments for these tasks. We need you to do that. We'll come back in 7 days or however long it is. And we want to see that you've actually taken steps to mitigate any further risks. So internal investigation process. So who's the person undertaking the investigation? What have they done? What's their qualifications? So I often get people that'll turn around and say that they know how to do an internal investigation, and then I'll come in and I'll do an investigation and find they have not even interviewed the worker's immediate supervisor. And if they had have, they would have seen that the claim was an automatic acceptance based on what it is, and it would have saved themselves about $3,000. It's absolutely ridiculous how many times I've seen that. There's one particular company, and I won't name them, but they need a good kick up the arse as far as I'm concerned. Anyway, has any risk assessment, ergonomic assessment, JSA, been undertaken concerning duties? So the duties that the worker's performing, obviously. So there might be things like take fives. There might be things such as task analysis. Might be standard operating procedures, swims. Unfortunately, at times we might get certain companies who'll say, look, if I was undertaking swims and risk assessments on everything I did, I'd never get any work done. But that's not going to be a reasonable defence if the estimator goes to court. And that's the biggest problem. The biggest thing they're going to look at if the matters ever go to common law are going to be supervision and training, any risk assessments, and an induction and training that's been provided. Right. So we want a copy of those risk assessments, and we want to see have those risk assessments and standard operating procedures, SWIMs, been updated, or has it been something that's been sitting on the shelf and done back in 2010 when we're now in 2025? So now we go into the injury stage and we look at how did the workers' alleged injury occur? Who was involved? Yeah. So what do these guys do? They stood and watched. All sorts of things.
Yeah, they just stood and watched him get stuck in the lift and go up. So, but they were all witnesses to it and they were there at the time. So we've got 1, 2, 3, 4, 5, 6 witnesses to that injury at the point that it happened.
Yep. Where did the alleged incident occur? So obviously in that one, at the lift, at such and such address, at 5 o'clock or whatever time it was, waiting to go home. What was the date and time that the injury incident occurred? So big time thing we often get is we might get the date, but there's no specific time provided. Now, when you look at this, you're looking at the who, what, where, why, when, and how. As you hear Mike say, as part of the investigation training he provides at the Australian Security Academy, in every single course I've ever been in with Mike, he reiterates that over and over and over again, because that forms the basis of every single investigation and every single question you're going to get. What time did the worker arrive at work and commence their duties on this day? So they might have come to work and actually been waiting around for half an hour, doing other duties or other things not associated with their role when they actually got injured. And it may have been that they weren't expected to do that. They just took it upon themselves. Yes, yep, main contractors and subcontractors and that, so they'll often be required to put in risk assessments and have inductions before their staff members are allowed on site. Those inductions and training may be provided by the principal employer for the subcontractors, but there should be a record for those persons that's kept by their company as well. You go on mute again, Mike.
In 2025, there's a record of everything, and the induction doesn't have to be a 3-week induction. The induction has to be relevant to the workplace, and it has to involve personal protective equipment, risks and hazard identification, people's duty of care to report hazards, that sort of thing. All these are discussed during that induction process, and it is recorded and signed off today. So there's no mucking around anymore. So if they don't have a record of that induction, that is a serious matter in 2025 moving forward. You've got to ask for it, and if they say, no, we didn't, then you've got to say, you've got to put it on your big investigator's pants and say, why not? And get an answer. Do not leave that building until you have an answer from that person you're interviewing at why didn't they have an induction.
And the other thing is, some of these things, sometimes you'll see a signature on there, but no name or anything printed or written next to who that person was. Now, that is not good enough. You know, that's I mean, I can give that to a 15-year-old kid, you know. We want to be able to identify who that person is 100%. Is this your signature if the matter goes to court? You know, did you sign it? No, that's not my signature. Okay, well, whose signature is it? It does happen. What duties was the worker performing at the time of the alleged injury or sustaining the alleged injury? So was it duties that were consistent with their role? Was it duties that were over and above what they were expected to undertake? Were they filling in for somebody else? Had they done the duties before, or was it something new to them? What training had they received? They may have received further training, they may not have. What instructions had the worker been given immediately before sustaining the alleged injury? Had they been given additional instructions over and above what they would normally do? Or were they just left to undertake the duties with minimal further information?
And what you'll find is there'll be a person there that drives that crane inside that big construction warehouse, and that person is away or on leave or absent for some reason. There's a critical point in the construction of something where that is needed, and someone will take it personally on board to jump in and drive that crane because they've watched him do it and they know how, right? They've never been inducted into the operation of it. They've never received any training of it. They've watched the person do it, and then an incident happens and someone is injured as a result. You must not shy away from it. You must go deep into who told the person to do that. This is critical. If they decided to do it themselves without permission, that's way different than if the supervisor said, oh, Harry's away, Fred, go and drive the crane. We want to know that, and it's got to be in the statement of the witnesses or the employer or whoever it is you're taking the statement from. The exact words, the exact details, who told the person to do that must be answered.
Do they have a license to operate the crane? So have they been signed off as the employer, signed them off that they can actually operate that crane in a safe manner? Exactly. Who, what, where, why, when, and how. So who gave the worker the instructions and how were they provided? Was it verbal? Was it written? Was it an SMS text message? Was it a WhatsApp message? Was it a morning meeting where they had Skype or FaceTime or something like that? Zoom meeting. Is there documentation available evidencing these instructions? If so, obtain a copy. So they might have a job sheet that says, take this pallet and go and put it into the racking and then pick 5 objects off this other pallet, whatever. What time did the worker arrive at work on this? That's the previous slide, I think. Sorry. If the alleged injury is a repetitive strain injury, when did the worker first experience symptoms? So this goes into the gradual onset part of the actual physical injury. So there might be something's occurred and the worker hasn't thought much of it, and then all of a sudden, over time, the injuries gradually become worse to the point where they can no longer work or put up with the pain. And they could then go off and seek further medical treatment or first aid. So when did they first seek any medical treatment?
No, instructions can be, good question, really good question. Instructions can be given verbally, they can be given in writing, they can be given on WhatsApp, by email. They very rarely do they use smoke signals, but you know, the instructions must be identified as how they were conveyed at induction in the standard operating procedures. Every morning you go in and you put away the guard dogs before anybody else enters the premises so no one gets hurt or whatever it is. It's in your standard operating procedures and you're expected to do it. And suddenly that guard's disappeared. He was given the instructions, new ones come on and they didn't. Someone's been bitten by one of the guard dogs on the premises. So writing is a great way to have it because you're going to have a record of it, but it may have been at induction. Verbal, nothing wrong with verbal instructions if they're correct instructions, right? So nothing wrong with that. If someone heard it and it was conveyed correctly and they understood what it was all about, then you can get it into the statement and it can be confirmed.
And in 1997, I turned up to an earth mover that I was going to work for and do a bit of work with a front end loader. They threw the keys to me and said, go and have a go. Nothing else. That's it. Here's the keys, go and have a play. You know, so you don't always get instructions.
The worker
Pretty
doesn't have
rare.
to prove. Yeah, the worker doesn't have to prove anything. The worker's lawyer will do all that for them. We don't have to worry about that. We're concerned about the employer. We are legal defence investigators. That's what we are. Okay, so we work for the person who's going to pay for an investigation to defend the claim against them. So an AMBIT claim against someone could be $5 million when we go out and do our investigation and find out that they didn't follow instructions, they didn't wear PPE, they had their induction, but they refused to work as they were told, and they've received 2 warnings, then their compensation is going to be reduced because of their own actions in that case. So we're only worried about what the employer does. How the worker goes about proving things is up to them. We're interested in what the employer does, their processes, policies and procedures in the defence of the claim. In doing so, we're not working for the employer or against the employer. It's not one against the other. This is a no-fault scheme. We are finding out what happens, and that's a good point you've raised there.
And the onus there is more so on the employer to show what instructions they're provided and how they're provided and whether they're documented or not so much the worker in that case.
The worker will later on in common law come up with particulars of negligence, saying failed to provide a safe workplace, failed to provide a safe system of work, failed to provide induction, failed to provide instructions. All those things will be there 3 years, 4 years down the track. If we can get that into a statement early on, it's going to be a reminder for that person's replacement in 3 years' time after that person's retired, whatever, what systems were in place when it was at its statutory phase 3 years ago.
Another one that you find there in the common law is failing to undertake any adequate risk assessments and or refresher of those risk assessments and standard operating procedures. So again, if they've been sitting on the shelf for 5-10 years, why haven't they been updated? That's another big one. So the workers, when do they first seek any further medical attention? Who did they see? What was their medical diagnosis? So you might get this medical diagnosis of things such as the certificate of capacity. Did the worker require any further scans? If so, what did this reveal? So things like MRIs, ultrasounds, X-rays, any nerve conduction tests and things like that, if they've got carpal tunnel, any other specialist appointments that they've attended and have been given, a diagnosis or a conclusion of the injuries. What were the events in the days leading up to the worker sustaining their alleged injury? So, bit of a red flag. The person comes into work and says they've injured their arm or their leg or something after a long weekend. First thing they do is when they turn up on a Monday morning, they've injured themselves and all of a sudden they put in a work cover claim. They have yet to start work, or they've done 1 or 2 hours of work before they claim to be injured. Now, obviously they still can get injured in the workplace. It's not so they can't, but further questions have to be asked. What were they doing on the weekend? So I think there was a case years ago where a young girl came into work and said she'd injured her ankle at work, and then they found out that she'd actually been playing netball on the weekend and injured herself playing netball. I think that was one of yours, Mike, that you told me about previously.
Yeah. Look, it's endless. There's footy games and people get injured there. That people will injure themselves, gardening or something like that. And then they'll claim that on the way to work in the states where they have, the travel to work and travel back home coverage, they'll say, I slipped over at the platform of the railway station. And basically what you're going to be doing as the investigator, if that's what they say in their claim, and you go and interview the employer, if they say they were injured at work, right, and it was on the way to work and it's a travel to work claim, which in some states does apply, you're going to be going to the railway station and asking them for CCTV of that platform on the day, date and time that person reckons that they slipped over at that rail platform. It gets as complicated and to the nth degree as that. In some states, someone will put in a travel claim because they injured themselves travelling to work. But on the way to work, they dropped off a load with their trailer of firewood to their granny's place. And they injured themselves dropping off the firewood, which isn't work-related. And they'll claim that against their employer for their, broken leg or back injury, that sort of thing. So they can claim anything they like. What we're about is getting to the details of what they did. Okay, what time did they leave home? What did they drive? Who drove? If there were two people in the car, who was the other person? Where's Granny live? Okay, how often did you deliver wood there? Okay, why did you deliver wood there that day? What were you wearing in footwear? All this sort of thing. It's all going to come into it. Each one turns on its own facts, but they're all interesting. There's never two the same.
Yeah, things like whether the car was manual or automatic transmission. If they had a deviation from their normal intended travel route, why did they have that deviation? How long was it, and for what duration? What purpose? Like Mike says. Were there any witnesses to the worker's alleged injury? Who? What are their contact details? So what do witnesses say was the cause? So the witness might say one thing and the worker might say another. They might say he was clowning around, being silly, riding around in the back of the ute, and he fell out. He wasn't wearing a seatbelt. He wasn't in the cab as he claimed. What did the worker report to witnesses as a cause of their injury? So what did he report? And how does that stack up against what witnesses say? Now, you might find that it says one thing on the worker's injury claim form, and it might say something totally different on the incident report. Make sure that both versions go into the report. We don't change anything. We don't try and assume anything. We let it plan out, and then they can look at the inconsistencies and they can start putting the pictures together. So the worker might change their story as to how the alleged injury occurred several times, and you hear a different version of events. So they say they injured themselves at work, but then they might turn around and say, oh, yeah, no, I got up in the morning and I slept the wrong way and I was feeling a bit of pain before I came to work. How could the alleged injury have been avoided? So what could they have done differently? Could they have stepped back and thought about the process beforehand and looked at a different way of doing things rather than being a bull at a gate, going in there, trying to pick up the 23-kilogram box on their own, rather than saying, hey, Mike, can you come and give me a hand with this, mate? So those couple of extra minutes to do the task might be the difference between somebody getting injured and having a back injury that affects them for the rest of their life. What could or should the worker have done differently to avoid the alleged injury? Same thing, basically. What could or should the employer have done differently to avoid the alleged injury? So the employer obviously have administrative controls where they can do certain things to ensure that they mitigate any risks of musculoskeletal issues, which is the big one that will always come up in common law. Failing to provide a safe system of work, failing to provide a safe place of work, failing to provide any control measures to mitigate musculoskeletal issues associated with the worker's role. So they've got to be able to show what steps they took, what training they provided. Okay, what have we got next? Post-injury. So provide a summary of what has occurred since the alleged injury incident occurred. So what steps have been taken? What communication has the employer had with the injured worker since they ceased work and went off to their doctor? So they may be an internal investigation that's been undertaken. So you want to know what's been included as part of that. and who's undertaken it. You might be looking at things like, the treatment they've received from their doctor, how often they've been to their doctor, what their certificate of capacity states, whether they've got a capacity for suitable employment or no capacity for employment at the present time. Now, sometimes this is where it extends to another subheading called treatment. So you obviously segregate the post-injury and treatment from each other, but you might be looking at things such as return to work plans and what those return to work plans state, whether there's any duties that are alternative, the length of those duties, what they include specifically. So somebody might be back in the office undertaking administration tasks rather than being out on the floor picking and packing orders, especially if it's a warehousing type environment. When did the worker cease work as a result of their alleged injury? Have they returned to work? What return to work planning has been undertaken with them? Has a return to work plan been prepared? Why or why not? Well, the worker doesn't have the capacity at the present time to return to work, and we don't know when they're likely to return to work. So we haven't gone ahead with any return to work planning owing to the incapacity. Okay, we might go to the next one there, Mike, please.
It gets really messy in psychological injuries when they want to send the worker back under the same supervisor. So this happens it doesn't happen in the office in the city. It happens in the police department. It happens in the education department. It happens in the health department. The person's gone off with a psychiatric injury. They've agreed to return to work on duty somewhere else, but there's nowhere else to go. The only person with the qualifications and the skills they've got is directly back under that supervisor. It's a nightmare. It happens. And if you get that explanation, it's an explanation why the person can't go back to work, and you've got it in the statement from somebody, whether it's a supervisor, HR manager, workplace health and safety officer, whatever. It's important to include that in, because like I said right back at the beginning, 5 + 5 does not equal 10 all the time in our world. There are a lot of affecting factors. If you get the information into the statement, there's explanations for those factors.
And you might have the situation also where the person has, they might have a second job, and the employer turns around and they'll say things such as, well, how come they're allowed to work elsewhere, but they can't work for us? Well, it's because half the time they're not coming into contact with that same supervisor that's been allegedly bullying and harassing them in one workplace that's not obviously present in the other workplace. Has the worker indicated any issue in undertaking their current duties? So since returning to work, has there been any further problems? Has there been any further issues with their shoulder injury or their knee injury? Okay, tell me what specific duties were they performing at the time that this has occurred? So there might be a written record from the employer. They might have taken notes in their diary. So we obviously get a copy of those notes or emails or anything else to say what further problems has been. And then what has the employer done to change those duties? Have they gone back and then rewritten the return to work plan or consulted it again with the worker's GP to change those duties? Have there been any changes made to the relevant systems of work because of the worker's alleged injury? Now, specifically, because of the worker's alleged injury, not just because of the workplace. So engineering controls, they might have put a gate where when it's open, it automatically stops the conveyor belt so that they can get up and clear things off the conveyor belt rather than having somebody get on the conveyor belt and have that conveyor belt continue to operate, where persons can potentially get their hair stuck or fingers caught or whatever else. Substitution, is there another way of doing the job or completing the task? And obviously the last one's going to be elimination. So the elimination is obviously when, they stop doing certain tasks altogether and they decide we're going to do this another way, or it's just just too dangerous to continue in the same manner. So what changes have been made? When were they implemented and by whom? How were they implemented? Does the employer have any documentation available evidencing when changes were implemented and how they were implemented? So you might be in a excavator or another bit of machinery that has a faulty seat, and you've had numerous operators complaining of issues with their backs, and then the employer decides to change that seat to another model. So when was that change made? How was it implemented? Who installed it? Was it the employer? Was it the employer's mechanic? Was it a third party? Was it the manufacturer? Was it under warranty or not? You might ask for a copy of the specifications for that machine. We might go to that next slide. Has the injury been reported to WorkSafe? Did WorkSafe come and investigate? Was there an improvement notice issued to the employer? If so, get a copy of that improvement notice. Okay, so obviously in this scene here you can see police and ambulance attendants. So sometimes you might be able to get a copy of any police report. If the employer has been provided with a copy, you may not always get it from the police. They might sometimes have to go under the Freedom of Information Act, and that might take 6 weeks to get a copy of that. We might just go to that in the next slide, please, Mark. So thank you for watching. So if there's any questions anyone has, more than happy to answer a few of these. Also, I can't see it at the moment, so I might have to. No volume, Mike.
There's no questions at the moment, Andrew. Mate, I'd really like to express my appreciation, and everybody that's been watching, our appreciation for your contribution to Investigations Uni during 2024-2025. It's been absolutely amazing. The information you share with people is appreciated by beginners, medium sort of term people, and highly experienced people who hold masters in investigations and doctorates in investigations. What you deliver each week, Andrew, when you do it, is the practical application of the real world of focused investigations on specific areas. And you've done it here in RSI, in questioning techniques, in what areas to explore consistently every week. It's been absolutely amazing to watch. And we really appreciate what you've done for us. We're looking forward to seeing you again in the new year, mate. And moving into 2026, it's the Australian Security Academy's 25th year of operation. And you've got some fans out there, Andy.
Yeah, thank you. No, much appreciated. You're going to make me cry, voice. I'll probably go off and have a bit of a sook in a minute.
But we really appreciate it, mate. I've got to run now. I've got to go over to Spy Curious, and we're looking forward to seeing you later on in January 2026, joining us back at Investigations Uni. Thanks, mate.
Thanks, Mike. And look, to everybody, have a safe and Merry Christmas and a Happy New Year. Whether you celebrate Christmas or not, I'm sure you'll enjoy the break if you get a chance. Thanks very much, guys.
Yeah, thanks, let's all have a spill. I'll talk to you soon, Andy. I've got to run, mate. Okay?
So thanks, mate. Catch you later.